So before beginning with the live demo session, we would like to understand what you have been doing presently, whether you are a law student or whether you are a legal professional working in litigation or preparing for judiciary or preparing for competitive exams, what you have been doing till now. So let's start with you, Lidansha. Lidansha, are we audible? Priyanka, are we audible? Priyanka, are you able to unmute yourself? Okay, Priyanka, you are not audible if you are trying to say something. Siddhi?
Hello.
Yes, Priyanka. Now you're audible.
Oh, okay. Hi, everybody. Actually, I was preparing for judicial services till now. I graduated in 2023, but now I wanted to enter into the corporate.
Okay, all right. So you were preparing for competitive exams, but now you want to make that transition. So that's why you are planning to learn the requisite skills so that you can make that transition. Wonderful. Siddhi, how are you audible?
Hey, hi.
Yes, Siddhi.
I'm actually already working as in-house, but I just wanted to upskill a little bit.
Okay, all right. Perfect. Sobia, Sobia, are we audible? All right. Lidansha, are you able to unmute yourself? Lidansha, I see you have unmuted yourself, but you're not audible if you're trying to say something.
I
Uh,
think Pragya, let's just start
sure.
with the
Let
session.
Yeah, let me share my screen. Okay. Is my screen visible to all?
Yes, it is.
Okay, perfect. So guys, we have prepared screenshot of two of the most important clauses in an agreement, payment terms and limitation of liability. So herein we just want to check like what do you review for in these clauses, because considering in an agreement these are two of the most important clauses which you will review for and negotiate on very regularly when you are working as an in-house legal counsel. And if you are appearing or planning to appear for interviews as in-house legal counsel, there's 100% guarantee that you will encounter cross questioning from these two clauses. So we have presented two clauses. First is payment terms. Let's read 3.1, which is subject to satisfactory performance of the services by service provider. ABC shall pay service provider fees as consideration in accordance with the terms and conditions of this agreement for rendering those services. Service fee is inclusive of taxes, if any, levied under the applicable laws except GST. GST, if any, shall be payable by ABC at such rates as prescribed under the applicable law, in addition to the service fee and subject to the fulfillment of conditions prescribed in clause 3.4 of this agreement and annexure 2. Payments of service fee will be subject to withholding of taxes at the applicable rates. Now 3.2 states ABC shall be entitled to retain or withhold any or whole of the service fee including GST, if any, payable thereon in the event service provider breaches any of the material terms of this agreement or is not in compliance with the conditions stipulated above until the same has been complied with or the requirements under the applicable law in relation to this agreement have been adhered to. Further, they states such retention or withholding by ABC shall not be deemed to constitute a breach of ABC's obligation under this agreement, and service provider agrees that it shall not seek any remedy, relief, or claim from ABC in relation thereto. Now, considering the fact we are representing service provider, these are the clauses that have been shared by the legal team of ABC. We are service provider, ABC is the client. Now, as a legal counsel of service provider, do you think 3.1 and 3.2 are acceptable, or would you suggest any changes to this? Let's start one by one. Priyanka, 3.1 and 3.2.
I
Will you
have no
accept?
idea.
Okay, all right. Siddhi, Siddhi.
I'm just rereading. I'm just rereading the clauses.
Okay, all right. Aishwarya.
I just joined the session, so could you please come again? I mean, repeat the context.
Okay, all right. So we are just gathering, like if you are appearing as for an interview as in-house counsel, these are the clauses that have been put forth to you. Now, as a legal counsel, they want to understand, or we want to understand, if you would accept it or if you would reject or propose any changes, so that we can understand that you have practical knowledge and guidance with regards to contract vetting and negotiation. Because if you are appearing for interviews as in-house legal counsel, that's the first thing that would be checked. So we have gone through 3.1 and 3.2. Now, as a legal counsel of service provider, would you accept 3.1 and 3.2, or would you suggest any changes to that?
Pragya, it will be better if you maximize it a bit, zoom in a bit.
Yeah, sure. Is it better now?
Yeah, I think it's better. So guys, first of all, it's like whenever you are expected to work as an in-house counsel, the most important skill set that is required is contract drafting, negotiations, and contract redlining. So here, via today's session, we're gonna show you how and what is expected out of you once you work as an in-house counsel. That is a corporate lawyer, corporate counsel. So this is something which we need to understand because theory will help you merely 5%. 95% of the work is the practical knowledge that will help you out for clearing an interview plus on the job itself. So, we are showcasing one of the most important clause, that is a payment term clause. So here itself we have taken out two of its sub clauses here itself. So do you guys think you can take 2 minutes or 5 minutes either and just go through these clauses and at the current position, like at present, do you think it requires any of the changes? And in under this situation, you are representing legal counsel of a service provider. So you have to think it from that perspective, whether these clauses are okay to proceed with or do we need to make any changes. So it's 12:11. We'll take 2 minutes. You guys can read these particular clauses and then we'll go ahead with the discussion.
So, is the service fee paid in advance or paid in arrears?
So it would be paid on monthly basis.
It will be like at the start of the month before providing the services as an advance,
No,
or
no, no. No. Once you have provided the services.
so it's paid in arrears.
Exactly.
Okay, okay.
So now, as legal counsel of service provider,
Hmm.
are both the sub clauses acceptable to you, or would you suggest any change in those?
I would require clarification with regard to the last line of 3.1. The payments of the service fee will be subject to withholding taxes at applicable rates.
Mm-hmm.
So what taxes are you talking about? Because in the initial stage you say that it is the service fee is inclusive of tax except GST. But in the last line you say that it can be withheld.
Okay, so when we are saying talking about the last line, they are talking about TDS or tax deductible at source.
Hmm, hmm,
So
hmm,
if
hmm.
as per the applicable laws, they are required to deduct that at source, so they will be deducting that tax and that would not constitute a breach of the agreement. That's what the last line suggests.
Okay, then what about the taxes that are covered in the fourth line? The service fee is inclusive of taxes.
Yeah, so that means that whatever the service fee that service provider has quoted to the client, in addition to that, over and above that, there would be a GST rate that would be applicable. So the total invoice that would be billed to the client that will include your service fee plus the applicable GST rate. Whatever the total amounts come, that would be billed to the client. Out of that total amount, if client is required to deduct any percentage as per the applicable rate, then the client will deduct that and pay you rest of the amounts. That's what client is suggesting there.
So from what you say, I understand that there is a TDS and a GST clause.
Yes.
If the service fee is inclusive of taxes,
Mm-hmm.
then do you think the last two lines are applicable? How can they withhold it?
That's what I want to understand. That's what you have to tell me whether this is applicable, and if not applicable, what are the changes you would propose in that?
So I would say, as an in-house counsel,
Mm-hmm.
if at all there is any discrepancy in the invoice that is being raised,
Okay.
so I would keep a clause saying I'll give them two of the options as per the industry that as per the company policy. Either they should pay the amount in full and then raise a dispute. So in case we find that there is a dispute that is admittable and it is favoring the client, I would say I would refund the amount. So I would either give this option, or as per the policy, I would say you can pay the undisputed amount, and as
Mm-hmm.
per the disputed amount is concerned, we can resolve the dispute, and then we can go for the payment.
Okay. All
But
right.
Just a second. So, Aishwarya, I have a counter question here itself. So, for an instance, I am representing legal counsel of a client.
hmm,
So, if I agree to pay you, and
hmm,
in case it is to be found that the dispute is on your end itself, so you are saying you will refund me the amount, right?
exactly. Only
So,
after the dispute is resolved.
yeah. So at that particular point of time, being a client, I'll ask you if that amount is 1 lakh rupees, and in case it is to be found that the dispute is at your end itself and it's your fault, so I'll charge 50x of that amount.
We wouldn't agree for any penalty or payment from our side for holding the
But
amount,
but
interest
the
charges.
dispute is from your end. It is proven.
Yeah, it is only regarding the amount. We don't agree for any penalty charges for the same, except if it has been explicitly covered under this agreement. There might be issues with the invoice in multiple ways. There might be a miscalculation. So that is one thing, miscomputation errors, and certain other things, or for the damages that we claim, or for the repairs that we claim, or for the deficiency in services of any kind. So I would make sure that I classify them, and I make sure that those disputes, we are not liable to pay them any penalty for the amount. We will just refund the amount. That is what we will agree as a company, service provider.
Okay.
All right. So
So
Ishwarya,
the last two lines, yes.
first thing here, the last line, it's not talking about dispute mechanism or disputed invoice. It's talking about statutory obligation under the Income Tax Act that you are required to deduct tax at as per source at 10%. It is talking about statutory obligation. What you are talking about is an invoice dispute that would be raised by the client.
That is what my question is. In the fourth line, you say that the service fee is inclusive of taxes.
Yes.
Then, if you're only going to pay the service fee, that doesn't make any sense here. That there seems to be a contradictory statement.
So Either you will remove the last line or you will suggest change under this statement. That's what
Yes,
you're suggesting.
exactly. Yes,
So
yes, yes.
I
I
want to
would
know
not.
what change would you suggest?
I
Whether
would
you'll.
just suggest the last portion of the part saying
Hmm.
where the amount of service fee that is being paid,
Okay.
the equivalent tax should also be paid. We cannot say that I will pay just the total principal amount of the service fee instead of paying a whole of the taxes for that.
Okay.
So it
All right.
goes hand in hand.
Yeah. So can I interpret that you're saying that herein the service fee is inclusive of taxes? Instead of that, you'll write exclusive of taxes?
If the company policy allows, if the company policy is saying
Mm-hmm.
that the service fee is inclusive of taxes, then for example, the service fee is 10,000 and they
All
have to
right.
pay some tax for that. I
Mm-hmm.
would require them to pay it in full. They cannot say that I will pay only 8,000 or a certain amount of the taxes and I'll withhold the extra taxes.
All
Rest of
right.
them.
Okay.
First thing.
So
Second thing is
yes.
that I would
Mm-hmm.
require scenarios where they would withhold the taxes. I would require an explanation for that, and I will also get back to the team to check whether it can be agreed or not.
Okay. Perfect. That's the changes you'll suggest in 3.1. What about
Yes.
3.2?
3.2 again. Just give me a moment.
Yeah, sure.
So this question is for everyone and not just
Uh,
Ishwarya itself.
can
Like
I,
we have, yeah.
Yes. Yes, Priyanka. Please go ahead.
if we write the exclusive of taxes in the point one, then we have to do the same in the point two also, right?
Okay. So point two, where is it talking about tax? Where you want to exclude the tax?
GST.
Okay. So you are saying that we can agree ABC shall be entitled to retain, withhold any part of the service fee, but not GST, right?
Yes.
Okay. All right. So Priyanka states that she can agree to retention of withholding without the GST. Siddhi, what about you?
I would probably remove this part where they can withhold the service fee and introduce a provision for disputed invoices.
Okay. All right. So
So
are
can
you?
I continue?
Yeah, yeah, sure, sure.
Uh,
Yes. Sorry for the background. So
Yeah,
with
sure.
regard
Please
to
go ahead.
3.2, I would say they cannot withhold the GST because it's very obvious that for whatever the
Mm-hmm.
service fee that they have paid, they
Right.
should pay the GST unless and until there is any dispute with the GST invoice that we have raised. There is no obligation on their part. There is no right on their part that gives them the right to withhold the GST.
Okay.
First thing. Second thing is that unless there is a non-cure or non-remedy of a breach of this agreement, I
Right.
cannot give them the right to withhold anything. I must require a cure period for the same.
Okay. All right. So,
Second thing, yes.
right. Yeah. Anything else you would suggest in this?
yes. Can I suggest?
Yes, yes.
In the last second line, service provider agrees that it shall not seek any remedy. I think this should not be there. You cannot
So,
stop the other person from seeking any remedy relief.
okay. All right. So, are you going to delete this or would you suggest any alternative to this?
I
I'm
think there
going
can be an alternative.
So I would provide an alternative where the 3.1, the scenario that you said that I would charge you more like a penalty because the dispute is from the service provider ends,
Mm-hmm.
and when you're going to refund, I'll be charging you a penalty for that. So if they are going to charge me a penalty, then I'm going to charge them a penalty or an extra charges when the 3.2 scenario arises. If there is no breach from my side, but it is only on their side,
No, no,
breach
no, no,
again
no.
has to be proved.
Just a second. So first of all, I want to make these things clear. Here we are representing legal counsel of a service provider. So, So I have just a question out of curiosity. Like, Aishwarya, are you already working as an in-house counsel? I think someone said, right?
Yes, I am.
Okay. So, like, in how many chances or cases do you think your client will agree for the penalties? Or there are high number of chances of losing the client itself. Whenever I am quoting, I'll charge penalties from you.
Okay, that's why I said when the
Right.
brief is not remedied,
Hmm.
then they can go for all these things. So I will always give them alternate remedies, and only after
Hmm.
exhausting all these remedies, there will be the cost part that comes into place.
This part you I think definitely agree. If I'm asking my client, like I'll levy penalties on you, or I'll if the fault is on your end, I'll charge this much amount or this X amount. So I'll definitely lose on the client, right? This you
Your
agree.
voice is breaking. Can you just come again?
So I am asking if I'll be asking my client, like I'll levy this much amount of penalty or this much amount of particular amount if the that particular dispute is from your end. So there are high number of chances I'll lose on the business as well as that client. Do you agree on this pointer?
We will make sure that we are covering them on rest of the agreement. Only in that case we will provide this option. Or else we will say that we will just add up to the number of days that we require to cure the same.
The max. So you are
Yes,
also coming on to the this particular point itself. The maximum I can negotiate is on the cure period,
exactly.
right?
It's
Okay.
only in the last resort that we ask them that it will go 3.1 and 3.2 goes hand in hand. It's only in the last resort. I'll just try
Yeah,
to maximize
because
the cure
r-
period.
yeah, I definitely agree on this point, but I was not agreeing on that particular point where I could suggest this particular pointer to my client. If the fault is on your end, I'll charge this much amount. So I think at that particular phase, my client will disappear. Like we'll run out of business because
All those
you.
things will be
Hmm,
explained in the agreement, where we
right.
will
So
explicitly mention certain scenarios saying if
because
this.
whenever we are working as an in-house counsel for a service provider, we always have a lower hand. This is like the practical
True,
standard
true,
which
true,
is followed, right?
true,
Whenever we are working as a legal counsel of a client, we always have an upper hand. I ask for termination for convenience. I tell it to my service provider, we are not giving you this right. It
true.
is agreed, it is acceptable. But where I am representing legal counsel of a service provider, it is difficult to negotiate with my client. I need to be like really polite while I am giving out all the alternates because again, that will definitely backfire on you itself. Your business will say to your management, the legal counsel was really adamant and was tough and they were rude. Hence, we have lost this business. So my
True.
work as an in-house counsel is just to highlight and give the alternates that is in line with my company's policy. But I cannot state something that I also know definitely will lose out on the business itself.
True. That is this is always given as a last resort from my it's all based on my experience. So whenever we receive a same scenario, we will just try to maximize the cure period that has been
Right.
insisted on
Correct.
us. It's only for
Because
the clients who
right.
insist more on us, we will try to take an upper hand because we
Now
would have
I
compromised with them on some other part of the agreement.
I have a question. So you said like for an instance, if there is some material breach or things like that, client
Hmm.
is asking for upfront deductions. Like I'll deduct this amount from your invoices. But you said we'll follow the process, and if it is to be proven, then I'll refund you the amount.
True.
But out of 100%, what percentage do you think your client will agree on this?
It is always like we give them the SLA for the same.
Hmm.
So we'll make sure that we give the SLAs, and we will try to minimize their expectations with regard to the cost, penalty charges, either getting it from them or giving it from our side. So we'll
So,
make sure that.
like if I am giving this particular option to my client will simply say,
Hmm,
okay, understood. I will not deduct from your pending invoices. So you are saying once it is to be proven, once it is proved, like it is your fault itself, then you'll refund me the amount. But at that particular point of time, I would want that particular amount to be 50x and not that single amount as a rebuttal.
If I have the permission from my company, like we will be given a certain extent of responsibility or flexibility, right? If other parts of the agreements are being compromised, then I'll not agree for this. If the
Right.
rest of the agreement
So
is not
what
being compromised,
basically
I'll
what
definitely agree for giving them the penalty charges.
right. So what I mean to say is we will never speak those factors which will backfire on us, because I
True,
have
true.
seen myself on the negotiation call. If
Hmm,
I am quoting something like, okay, I am not agreeing to your upfront deduction, I'll pay you back. At
hmm,
that particular point of time, it's like 99% of the time client is saying, okay, I can agree to this. If you agree, you will pay me 50x of that amount. That is something which no company will agree,
hmm,
irrespective of their
true.
company's policy. If
Hmm.
that damage is for 1 lakh rupees, which I have to refund. So he's asking me for 50 lakh rupees. I don't think it aligns with any company that is there in India or outside India also. So
But
he,
the service fee will not include the damages. That's a separate deal as such. The service fee is only for the services that is being provided, right?
so when we talk about limitation of liability, so we make sure we are making it align with the service fee, like the cap amount. So it is always subject to the service fee, the cap amount that we are putting on the liabilities. Okay, I think Pragya, you can show them the changes that
Yeah, all
we
right.
would suggest.
So what I gather from your answers, Ashwarya, Priyanka, and Siddhi, what I gather from your answer is that you can agree to that, provided you initially have a cure period wherein you can cure the any material breach or defect that you have, and once it's cured, whatever the part they are withholding, they'll refund you back. If you are not able to cure the deficiency, then they can deduct the amount from whatever the amount they have withholded. That's what you all suggested in 3.2 and 3.1. It should be inclusive instead of inclusive of taxes, it should be exclusive of taxes. These are the changes that we are going to suggest in 3.1 and 3.2, correct? Or is there any other further change that we are going to suggest?
Last second line, the service provider agrees that it shall not seek any remedy.
Okay, yeah, perfect. So this line will also be deleted, or would you suggest any alternate change?
There can be alternative change, but I don't know as of now.
Okay, all right, perfect, perfect. Okay, all right. So herein the changes that we have suggested that was with regards to 3.1. Now 3.1 at the outset they have stated that subject to satisfactory performance of service. Now tell me satisfactory word it's not defined under the agreement. There is no capital S, so it's an undefined term. Now if there is an undefined term and had it been the situation that we had agreed to perform the services which are as per satisfactory level of the client. Once they have approved it is theirs as per their satisfaction level, only then they will be liable to pay us. If we had agreed to that, would be in our interest. It would not be in our interest for the sole reason being if tomorrow we perform the services for an entire month, at the end of the month client come back to us and says that your services were not up to my satisfaction level, hence I am not liable to pay you anything. That would hamper my business and my interest. Satisfactory word, if that is already defined under the agreement, I have to make it subject to that. Otherwise we cannot agree as an in-house counsel to keep an undefined term. That's why the first change that we were going to suggest was deletion of satisfactory word, and we were going to make it subject to scope of service. For the simple reason, whatever the satisfaction level is, however they want us to perform the service, that would already be defined by them, by the client under the scope of work or under the scope of service. So if they have already defined that, if we make it subject to the scope of work, they cannot go beyond that. They cannot change their satisfaction level tomorrow. So that's why the first change that we are going to suggest is deletion of the word satisfactory, and we are going to write that subject to performance of the services under the scope of work as defined under this agreement, ABC shall pay service provider fees as consideration in accordance with the terms and conditions of this agreement. Second thing, service fee is exclusive of taxes as correctly specified by Priyanka that and Aishwarya that service fee should be exclusive of taxes. It should not be inclusive of taxes. Why? Reason being because when I quoted my service fee, that was basis what I am going to receive. Taxes is a statutory obligation. I am not going to receive the taxes. That has to be paid to the government. So it is decided by the government. So my fees, what I quoted to you, that is not inclusive of taxes. That is exclusive of taxes. Now comes the last part. Payment of service fee will be subject to withholding taxes at the applicable rates. Now here, for your clarification, Ashwarya, what this concept suggests is that whatever the total invoice that you are going to bill me, out of that invoice, under the prescribed income tax act, the prevailing TDS rate is 10%. So if you billed me 1 lakh rupees, 90,000 as your service fee and 10,000 as the GST. If you are billing me 1 lakh rupees, as per the applicable rates, I have to withhold tax. It does not
Okay.
mean that I am withholding your service fee. Withholding service fee and withholding tax are two separate things. So this is
Hmm.
a statutory obligation which client has to follow. And it does not mean that they will withhold the tax and they'll keep it with themselves. When they will be filing their tax return, they will be depositing that with the appropriate government authority, appropriate tax authority.
Okay,
So
okay, okay,
since
understood.
this is a
So do we have
statutory,
any definition for taxes in this agreement?
yes, we will have.
Okay,
This is just to give you a reference that
okay, okay,
whenever
okay.
this concept says this is talking about tax deductible
Hmm,
at
hmm,
source. So if they are required to
okay,
deduct tax
hmm,
at source, they will do it. And this is a
hmm.
since this is a statutory obligation, as a legal counsel, we can agree to it.
Okay, okay.
Now coming back to 3.2. Now all of you said that you can agree to retention or withholding rights subject to cure period. If you're not able to cure within the cure period, then they can deduct from the retention or withholding right. Now, at the outset, we as a service provider, we can never agree to retention or withholding right. Even if we have got the cure period, still we cannot agree to retention or withholding right. Why? For the simple reason, if ABC or the client feels that there was a material breach on our part, it is a mere claim, it is a mere assertion. This is not a liability. So from the point of a claim being a proven liability, client has to prove various things. Once they prove all these things, then only it becomes our liability. Till the time it is not a liability, it is a mere claim, we can never agree to retention or withholding right. Second reason being that say we perform the services for an entire month. At the end of the month, we bill the client for a particular amount. Client states that on a particular date there was a material breach on your part. Now I'm not paying you even a single penny. I'm since you provided me with the retention or withholding right, I have given you a cure period. Cure it, but for the time being, I'm not paying you. That is not in our interest. At the outset, we can never agree to retention or withholding right. So that's why we are going to delete retention or withholding right. Instead of that, we are going to provide client with the indemnification right. Now, why do we provide indemnification right? Because through indemnification process, client will be proving everything that they have suffered damage because of our act to the tune of damage they are claiming. Till the time they do not prove these things, they cannot make us liable and they cannot retain or withhold our service fee, which we are entitled to receive. That's why instead of retention or withholding right, we have stated that ABC shall be entitled to indemnification right in the event service provider breaches any of the material terms of this agreement and is not in compliance with the conditions stipulated above. Further, we have added the cure period, which Priyanka, Aishwarya, and Siddhi, you have correctly stated that we need to have a cure period. Then we have added ABC shall duly inform service provider of such breach and have provided 15 days cure period and service provider fails to cure breach within the remediable period. So we have stated that you have an indemnification right, but only on account of expiry of the cure period. So if there is a material breach on our part, you will inform us, provide us with the cure period. If we have failed to cure the remedy within the cure period, only then you will have the indemnification right. But at the outset, we will never agree to provide retention or withholding right. So
Do
at
we
the
have
outset,
any limitation on this clause?
limitation of liability or limitation
Liability.
of what?
Limitation of liability.
Okay, yes. So when we provide indemnification right, now we will go to indemnification clause. Indemnification clause will states on what all accounts we are indemnifying the other side. Further, we will move to limitation of liability clause, and under limitation of liability clause, we will check whether we have capped our indemnification liabilities or not. So
Okay.
yes, through limitation of liability clause, we are going to cap our liabilities. We are going to put a cap on our overall liabilities, even under this clause as well.
Okay, thank you.
Yes. So these were the changes that we were supposed to present under the payment term clause, which is deemed one of the most important clause under the agreement. Now, why did we did this activity is because when you will be appearing for interviews as in-house legal counsel, you won't be asked meaning of a particular clause. You will be asked a situation-based question. This is what the other side or client wants. Now, you as a legal counsel, what would you do? So I hope this is clear. Any question, any doubt in regards to the changes that we have proposed? Priyanka, is it clear?
No, it's clear. Thank you.
Perfect.
So I
Siddhi?
just wanted to know.
Yes. Yes, Ashwara.
So I just wanted to know if you're giving the indemnification right,
Mm-hmm.
then the last line until the same has been complied with or the requirements under the applicable law. Do you think it fits in here?
Yes, obviously it's fit in here because we have asked for a cure period. Now, suppose today there was client feels that there was a material breach on our part. Now, under the agreement, we have provided that we have a cure period. So, whatever the material breach they feel that there was a material breach that has occurred, we have 15 days to cure that. So now, once we have cured that, all this point is over. If we fail to cure within that 15 days period, only then they will have indemnification right, not before that. They can't straight away claim that there was a material breach on my part and I'm simply moving to indemnification right.
Yeah, that is what is covered under this such breach within the if the service provider fails to cure such breach within the remedial period, that
Mm-hmm.
is your concern is covered under this. But my question, I feel like there might be a case where it says that until the same has been complied with, it kind of contradicts, like it gives them the upper hand, saying um, it gives them an unlimited period of time, right? There is no cap.
Unlimited, unlimited time period to client. For what? For what?
If you're saying there is an indemnification right,
Mm-hmm.
then you're also saying that only if it is not cured within 15 days they can go for indemnification, but there shall be a cap for the time period until for which they can claim for the indemnification, right?
Okay, so what you're suggesting is that there should be a time period for client to claim indemnification right, like 3 months, 6 months, whatever the time period, there should be a time period for them to claim indemnification right. Correct?
Yes, yes.
Now you are stating that this language until the same has been complied with all the requirements under the applicable law in relation to this agreement have been adhered to, provide them with the indefinite time period, right?
I just wanted to understand the logic behind this, that's it.
Okay, so our logic is that we have made it subject, we have added that you
Okay.
will only have indemnification right
Hmm.
once there was a material breach in relation to either the terms of this agreement or breach of any applicable law.
Hmm.
Whatever it is, there was a material breach on our part.
Okay.
If you feel, all right,
Hmm.
now once
Hmm.
you feel and you have informed us and you have provided us with the cure period,
Hmm.
so we have 15 days to remedy it.
Hmm. Hmm.
If within the 15 days we are
Hmm.
able to remedy it, then you will the whole point is over. Okay.
Hmm.
However, if the 15 days period is not over. Only post the expiry of 15 days, you will approach for an indemnification right. Otherwise, you don't have an entitlement to indemnification right. This, until the same has been complied with, will be read in consonance with 15 days cure period. It is not a separate, there is no full stop. It's not separate clause that we are providing them another right. This is
Hmm.
read, this will be read in consonance with the cure period that we have provided, that is of 15 days.
Hmm. Okay. Okay.
Further, to satisfy what you are stating, be the point with regards to a limit, the time period, limiting the time period within which you can claim the indemnification right, that
Hmm.
will be provided under a separate indemnification clause. That if these are the scenarios within which you can claim indemnification right. However, you must bring a claim within 3 months or 6 months from the date claim first arose.
Okay. Okay.
Herein we are referring to payment terms. So here in
Hmm.
payment terms, we can't resonate it with the time period for claiming something.
Hmm. 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 Okay. Okay.
All right.
Okay.
Thank you, Ashwarya. Siddhi, any question?
No.
All right, perfect. Sobia. Okay, all right. I'm not sure if Sobia is able to hear us. So, yeah, Achal. So now you can take it up. So we have discussed the important pointers, important clauses, and what all needs to be suggested and changed, and what all needs to be kept in mind while we are appearing for interviews as in-house counsel.
Thanks. Thanks, Pragya. So just a quick brief about how you can actually get practical exposure. Like this was just a glimpse. Uh, First of all, what we'll do is I'll just explain on as in like so there is a basically a misconception where we all know and we all like focus on the wrong skill set. But it's like people who just graduate from their law school or who just pass out or who are doing in some other industry, they think drafting is like the most important skill set or it's like the most important sought after skill. But when once you start to work as an in-house counsel, the most important skills that are required is contract negotiations and contract redlining. The reason behind this is contract drafting. You are not expected to draft anything from scratch because once you go and work as an in-house counsel, you already have set standard templates for each and every draft where you can pick it up. Also, second reason, once you are working for the service provider as their legal counsel, 99% of the time you'll get the draft of the counterparty, like the third party paper. So what you are actually required is you are required to have appropriate skills as in how you redline a draft or what you call it, how you vet a contract and how you negotiate on a draft. Because if negotiations start from the point itself, once I start to redline the contract, redlining is what which we just showed. Like redlining is basically making changes to the draft according to my company's policy. Okay. So negotiation is something which starts from that phase itself. It's like totally wrong if we think, okay, negotiation start once these redlining ends, but it's not like that. Whenever we are making any changes to a contract, I have to make sure I know its justification so that if tomorrow I am getting on a negotiation call with my client, with the other party, I'm able to justify it. So what we do is we take practical sessions and we provide practical exposure onto how you can achieve, how you can learn about contract redlining from scratch. It doesn't matter if you are working as an in-house counsel or you just recently graduated. What we do is we take up full-fledged drafts itself in the session from the beginning itself so that everybody can understand from their pace on their pace itself. So, like few of the USPs that we call it as like we which makes us different from other people is like these are totally live sessions. Practical exposure is there because we take whole full-fledged master services agreement and we discuss it in the live session itself. We redline it. I'll take quickly brief you about each and every individual sessions. Batch size maximum 20. Like we generally start a batch for within 12 to 15 people itself. One-to-one doubt connect. Anytime you can come to us for the doubts. Interview preparation. This is something which is like really important. Whenever any of the participants have any interviews, they come to us with the GDs and we help them to prepare as per the previous feedbacks, as per the present feedbacks, as per the feedbacks which we receive from our participants, 99% of the questions are what we discussed throughout the sessions and what we discussed in the one of the session that is totally dedicated to the interview preparation. You can attend the session as many time as you want. We have ongoing batches, almost 1 to 2 batches we start in a month itself. So you can attend as many time as you want, totally live. Help in smooth onboarding. So this is something which I think everybody misses out. So for an instance, I am working in the litigation industry. I was preparing for judicial services and uh, I just attained these skills, right? So I just joined somewhere as an in-house counsel. Now you will see in the corporate culture, like 95% of the time, nobody will put their efforts and sit with you and make you understand, okay, you need to do this, you need to do that, irrespective of the training that you will get. Okay. So there will be chances and cases where you have joined a new company and you are having few doubts, queries related to the work that you are doing in that company itself. So we'll be there, we'll be happy to help you, assist you there itself because I have seen in the corporate culture, nobody likes to spoon feed. So you'll surely get an assistance and help there itself. Plus, uh, talking about CV will help you to redesign your CVs as per in-house industry standards, like what all is required, what all keywords that are required there itself. So we have bifurcated, basically bifurcated in total 10 sessions itself, like whole of this. So the first session is something where we are focusing on everything about CLM, that is a contract lifecycle management, because once you go and work as an in-house counsel, you are expected to know in detail about contract lifecycle management so that you are aware on which stage you are, on which stage your contract is. So in the first session, we take everything prior to first session itself. We share an Excel sheet which have all the important clauses that are required, that are very like general and common to all the contract types. So before that itself, before the session one itself, you will get that Excel sheet. Once we start the session, obviously a quick introduction between every one of us. Then these all are those particular that are related to the CLM field. Like we'll get to know what is CLM, what are the stages, what are the pre-execution mode, post-execution process, what are the modes of execution, what are the important clauses, like what is like why is it important to learn a perspective which will give you a perspective and enhancement to think from service provider side as well as from client side, because I need to understand, I have to build up a thinking to start thinking from both the sides, because tomorrow if you are working with some X company, so there will be chances where you are representing a service provider, but there will be few cases where you are yourself taking few services or product. At that particular point of time, you will be representing clients, and but if you're just mugging up things, if you are not understanding each and every concept conceptually, so you will just redline everything opposite. So we need to learn that particular aspect also. In the same session itself, then in this the second half, what we do is we'll walk you through a full-fledged MSA. You will understand, you will learn, okay, this is how an MSA looks like, master services agreement. This is how all these clauses are placed. Okay, this is the legal language. This is the meaning of this particular clause, so that we are building a base before we jump on to the second session. Because in the second and third session, what we do is we take a full-fledged MSA, okay? We divide it into two parts. First part, second part. Okay. First part we cover it in second session. Second part we cover it in the third session. Now understand one point. To have a basic understanding till its advanced level, we almost put 5 hours, like 2.5 here, 2.5 here, to complete a single MSA so that we are covering everything. And it is from scratch. So in this session, you will learn about contract redlining, contract vetting on the draft itself from scratch so that you have that practical exposure. Okay, this is how I need to redline a draft. This is how I need to vet a draft. Now, once we are done with this, practically how will you learn the rest of the part is once you yourself do it. So after the third session, what we do is we give a full-fledged draft to the participant. Now all the participants are expected to redline it. Once you do, before the fourth session itself, you will submit it back to us. We will assess each and every draft individually, and in the fourth session we will discuss about the draft which was vetted by you guys, like all the participants, so that now you understand, okay, this was the pointer which I missed, this was the pointer which I did, but this is wrong, so that you're learning on it. And this is how you will learn it practically. Till the point you are just learning about, okay, what do you we understand by contract redlining, nothing will work. But when you understand, okay, this is how I need to redline, this is how we turn on track mode changes, this is how I accept, reject deletions, this is how I put up comments for different verticals that are there in our company. So if you are learning these aspects, you are upskilling yourself practically. So fourth session is dedicated to that, where we will be discussing the same draft which is vetted by you. Now, contract negotiation is something which is second most sought skill, second most important skill that is required, where both the parties get on a negotiation call and understand like what are the best alternate the other party can give. So in the fifth session, what we do is the same draft which me and Pragya have vetted in the live session itself. Me and Pragya will represent one of the party, like Pragya will represent the service providers and I'll be the client's legal counsel. We will negotiate on the call itself in the live session so that you get that learning. Okay, this is how I negotiate on a call professionally, ethically. These are the alternates that I give it to my client. So as I said, once you learn, now it's your time to showcase your skills, because till the time I am just listening to someone, I'll think like, okay, now I know everything. I don't have to learn anything. But your main learning point will be triggered once you yourself do it. So in the sixth session itself, you all will be negotiating with me and Pragya on the same draft which you guys have submitted it to us and which we have discussed and assessed, so that you all have an end-to-end learning. It was the same draft on which you have redline. It is the same draft on which you are negotiating with us. This will definitely boost your confidence. Okay, now I know how it is to be done practically. Then seventh session is something which I was talking about. Obviously, throughout the session, we're going to discuss about all the important questions that you will generally see. In the seventh session, with this particular question itself, what we do is we take up a full-fledged assignment, because nowadays, once you apply for any job position, there are 90% of the cases where you get an assignment, which shortlist you further, right? So we will discuss a good assignment there in the live session itself. And till this pointer, like before this demo session itself, we were concluding one of the batch and we were taking seven session itself. 90% of the people were total fresher. They have learned till sixth session. I just started showing the assignment and everyone was able to answer, okay, this I we need to change, this we need to modify, this is something I cannot agree. And then I just showed them the assignment which was selected and that person got into that company. Everything, like both the documents were exactly same to what they were understanding and which was discussed, and these all people were total freshers. So in the seventh session, we discuss everything that is like really important that we think is really important. And as per like now, it's been like it will be almost 2 years since we have started this initiative. And from the past participants, past people, I have been listening this fact like these all the questions are what we have discussed throughout the session. Now, I was talking about total 8 session, total 10 sessions. 8 session is something which is a one-to-one session where you can come up with your CVs and we can sit and work on your CV. Like we can give you an update, we can give our feedbacks. Okay, this is something which you need to modify. This is something you need to make changes to. And the last 2 sessions are drafting sessions. So in those particular sessions, one of the session will, as per certain facts, will show you how we modify and how we draft a clause. And in the 10 session, you will learn how you modify the clause. You will show us, okay, this is how I'll modify. So all these sessions are typically based on the practical exposure. Like if I have to go and I have to learn something theoretically, we have the internet. We have a lot of knowledge available on the internet, and I don't promote, yes, you need to have that basic theoretical knowledge, but just merely theoretical knowledge won't make you different from the crowd that is appearing for an interview. I have seen it. We have past participants from litigation background that has successfully switched to in-house. We have participants that were like we have. I think Pragya, we had a participant Srishti. She was preparing for judiciary, and now she had just switched and she's working with Colt Gurgaon. She was able to switch with the company because of upskilling. What matters is your practical knowledge, your practical skill set. So, I think that's it from my side, Pragya. As mentioned, we appreciate your time and interest in the. I never call it as a course. What we call it as like practical sessions because this is what we doing is out of pure passion because we at that particular point of time on in our time also we got so many problems because there were no knowledge there, we were not able to learn something practically. So this is something which we have started. So yes, we have doubts. Yes, go ahead. Aishwarya, you want to say something? Yeah.
Yes. So when you say contract lifecycle management,
Hmm.
do
Hmm.
I feel like you're covering the starting part of it because I see that you have the pre-execution and post-execution stage.
Right. So,
So
making it more clear, these sessions are typically for the in-house counsel, and we are not focusing on the post-execution process, that is data repository, all the abstraction, everything. That is something which a post-execution process involves, that are done by BPOs like Elevate, United Legs, Infosys BPM. So here in these sessions, what we are aiming, all the process that is there till the execution.
okay, okay,
Right, because it's like I have seen like me and Pragya while we were hiring someone, so we were like it totally depends and it's up to company's discretion. I'll like clearly mention it, but they were very against in hiring people who are coming from a post-execution process because there you will just are abstracting, you are doing the due diligence, you are just abstracting data from the already executed contract, but as an in-house counsel, if you are going and working, so your work is done till its execution. Obviously, renewals and amendments are there. It is again starting that particular cycle, but your work ends up there itself. So we are focusing from the pointer you receive a draft till you execute a draft.
okay. So I just wanted to know if you also cover when what happens when a contract
Hmm.
comes to an end and there is a renewal clause to it, or when there is a termination process that has been initiated by the client, and all those
Hmm.
small things that is also covered under the contract lifecycle management.
Everything will be covered. Like if I'll just brief you quickly about termination, if there is a termination notice which we sends out to our client. Like if I want to terminate, I'll just send it a termination notice to the client. which is in line with the notice period that is there in the MSA. So we will be talking about everything, all the amendments, like what is a change order, what are work request, everything. We'll be talking about everything. Plus any doubts, anything that you go through and you want us to take it up, you want us to discuss in the session, feel free.
Sure, sure. Thank you.
Okay, thank you. Priyanka, yes, do you have any doubts?
Uh, yes, actually, now I
Hmm.
have prepared for only judiciary, and I have not done any kind of internship, just one internship in the court.
I
So
was
I
just
am a bit,
okay. I was just talking about the same. We had a
yes.
participant, Srishti Arora, so she was also preparing for judiciary, and I think she had a gap also for 3 or 4 years. Now she is successfully working with Colt. So this is
And
what I
actually,
have to.
I graduated in 2023, so I have a gap of 1 year too.
She had a
So
gap of 3 years,
will
I
I be
think.
able to actually I have done zero internship, completely zero. Like the resume में कुछ भी नहीं है.
I will tell you, I have seen people who had done 15 internships. They are not able to procure jobs. I have seen people with zero internships, they are able to procure the jobs. See, I am not talking about these sessions. Let's keep these sessions aside. But as a pure guidance, understand one point. I have to hire a fresher. Okay. I have two people. Pragya is there, you are there. Okay. Now you have
Okay,
appropriate skill set. Okay. Both are freshers. Pragya doesn't have these skills. He only knows something which is there theoretically. Now understand one point. As a company, I will definitely go with you because my cost is reduced. I do not have to spend my time investing to spoon feed you from the scratch. So I have seen this particular pointer. Also, as an in-house counsel, you are expected to work on contracts 99% of the time. 99% of the time, company is managing their litigation work from outside counsels. They have their secretarial work managed by CS. So your main work definitely it will depend from company to company, but your main work will revolve around contracts. So if you are hitting on the right skill set, you will definitely ace in it.
okay. Actually, my question was even after getting the skills, actually ना मेरा resume ही reject हो जाता है.
So that
That's
is
the
what I'm
issue. But if
saying.
I do not reach till the interview, I will show my skill in the interview now. But
Tell
if
me
I do
one
not
thing.
able to
At
reach the
present,
interview,
does your resume talks about contract lifecycle management?
no,
Does your resume talks about contract redlining, contract vetting, contract negotiations?
no. I totally
Then,
don't know about these terms too.
then Then
Yes,
understand one point that is where we were saying we help you to modify your CV as per in-house counsel industry. Your resume
actually
is
the
something which is like your first impression.
okay. Actually, my second question was the your
Hmm.
website which shows the courses. There are various courses, okay, but because I don't know the terms, I have zero knowledge about
You
industry.
can reach
Okay,
out to me or Pragya and we'll help you to
okay.
figure it out. That's not an issue.
Actually, I'm not able to figure out which course is good for me
Yeah,
and
yeah, yeah.
I have
That's
to
not
just
an issue.
okay.
So we
Thank
can
you.
sit after this session and we can just
Okay,
figure it out. So that's not an issue.
okay. Thank you so much.
Okay. So Pragya, I don't have anything to add. Do you have anything, or we can wrap up?
No, that's perfect. So you have covered it all. So everybody, whatever questions you guys had, so you have asked. And in case you have any further questions, feel free to reach out to either me or Anchal, and we'll be happy to help you. So thank you all for joining. Thank you for
Thank
taking out
you.
the time.
Thanks,
Have a good
This
day.
was a
Sudeep,
wonderful
Priyanka.
demo session and very, very helpful.
Thanks.
So, thank you so much.
Thank you. I hope you guys liked it.
Yeah, I think I had a good time, and I hope it's the same with others also.
Thank you. Thanks, Aishwarya. Thanks, Priyanka. Thanks, Sid.